Let's talk now about handling exhibits during this competition. I think that the decisions made by most law students preparing for this tournament relating to exhibits can feel like the most difficult or uncertain or almost alien decisions that a law student has to make. I think the place to start is to think about the examination of the witnesses you will be calling. Plan ahead, of course, and think about whether any of the pieces of paper that you have in the case record that's delivered to the team that you may want to use when you are examining your own witness or even when you are cross-examining witnesses on the other side. As a general matter, I think it is helpful for the team to assemble, say, 6 copies of the entire record in 3-ring binders, and to anticipate that you will be delivering copies of those exhibits during the course of each round where you are competing. Now, I suggest that the exhibits be put in a 3-ring binder because you will need to be able, possibly, to remove pieces of paper from that binder. In some cases, there are no exhibits that are in any way objectionable, and it quite nicely lends itself to the creation of what I want you to think of as a set of joint exhibits, and that would be presented to the arbitration panel with copies to the lawyer on the other side and for use with a witness being examined or cross-examined. You will find that I think virtually every team competing in the tournament will do this. This means that before the round begins, I encourage the students that are actually competing in that round, particularly the student who is playing the role of attorney in that round, approach the other side. This is before the round begins. This is before everyone has settled into their seats, and often it is before the judges actually walk into the room. Go up to the other side, introduce yourself, handshakes all around, ask them which student is playing which witness, and gender will always be a bit of a trip up here because you don't know whether the particular witness is going to be the same or different gender from the way you were practicing it. So by all means, introduce yourself to the other team. Now, that is the time when you want to talk about handling exhibits. Now, if you want to propose to the other side that you create a set of joint exhibits for the efficiency of the hearing, this is something that is actually commonly done in real arbitrations. When I am conducting an arbitration, I always ask the lawyers to please get together on exhibits so that we have a joint set of exhibits and not twice of the paper for the arbitrator that would otherwise land on my table. So, you are proposing a set of joint exhibits for use during the course of the hearing. Now, it may be, and about 1 out of every 3 years I've seen this, there will be an exhibit that you will want to challenge, or the other side will want to challenge, and not agree or stipulate that all exhibits are admissible. Now, since you have set yours in a 3-ring binder, it's easy to pull that out, that particular piece of paper out of the joint set of exhibits, and then you know that during the course of the hearing, that particular exhibit may require special handling, particularly if you want to introduce it into evidence. So, it's a good indicator. Well before the round begins, you will know which documents the other side may be challenging. And so that simply gives you the opportunity to prepare and to think about authenticating particular documents with the 2 witnesses that you will be calling. Now, having settled this with the other side, when the judges are in the room, And before the round begins, before any opening statements are made, that is the time to simply ask the panel if you can discuss with them a preliminary matter. By all means, tell them that you have discussed a set of joint exhibits with the other side, and with the other side, you've agreed that a set of joint exhibits are not objectionable, are authentic, and may be admitted into evidence. Be prepared at that point to ask if there's any questions or objections, and if not, simply hand a copy of the set of joint exhibits that you've brought to each of the members of the arbitration panel, one to the other side, and then you have a copy that you will use for examination of your witnesses. That is probably the best way to handle what most law students will find to be very unfamiliar ground, and that is handling exhibits and preparing to distribute exhibits for use during the hearing. Now, that raises a natural next question, and that is introducing evidence. What about that one exhibit that you know the other side does not want to stipulate is authentic or can be admitted to evidence? That's something that you will have to do with your witness on the stand. And by all means, watch our next video chapter on introducing evidence.